your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families and licensed immigration attorneys engage, learn and stay informed on the latest developments in US immigration. My name is GB Satusa and I'll be your host for today's session. Facing deportation, legal remedies that can help you stay in the US. Facing deportation is one of the most overwhelming experiences a family or a person ever encounter. Removal proceedings move quickly, deadlines are unforgiving, and one mistake can have life-changing consequences. Understanding the legal remedies available is critical for anyone who is detained in court or concerned about ICE enforcement. To guide us through this discussion, we are joined by Blanca Zarazua. She has been since 1987 and focuses on family-based immigration, deportation defense, and complex appeals. Her decades of experience, combined with her background working with major institutions such as Bank of America and the California Supreme Court, provide deep insight into the strategies that help families fight removal and remain in the United States. You're welcome, Attorney Zarazua. Thank you so much for joining us today. Attorney, I think you're mute there.
I welcome the opportunity to always connect with the community. I appreciate the invitation. Thank you so much. We're living a very traumatic time in our history in this country. Some of us would even say we're embarrassed at what's going on right now throughout the country for different reasons. And I really commend you for having the courage to do the research, to join this group and other groups that are providing vital information, credible information, and not in 30 seconds. We're going to go into as much depth as time permits because these are serious issues and serious consequences, and you deserve to get good, credible advice. If you're not getting it, switch attorneys, switch representative, and try not to go to a notario because they're not qualified to give you the information that you need. So thank you very much for the invitation.
Indeed. Now, before we begin, a quick reminder, immigrationquestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals can learn about immigration topics and engage with licensed attorneys who participate independently. To everyone joining us on Facebook, YouTube, LinkedIn, and all other platforms, welcome. If you haven't subscribed yet, now's the perfect time. Go ahead, hit that subscribe button, grab your notepads, and get started. Now, Attorney Zarazua, when a person receives a notice to appear, what are the first legal steps they should take to protect their rights and avoid missing critical deadlines in immigration court?
Well, the first thing you need to do is try to relax. Your head needs to be clear. Detention, even if you're detained, detention is not deportation. And a notice to appear is not deportation. It's a beginning of a process where you could have a very strong case and remain in the country. So let's not panic prematurely. What you need to do is get on the internet. You'll have an A number, most of you. and find the automated case status site for immigration. And you can type in your name and your A number, and it'll tell you if you have a court hearing or not. Sometimes it takes time for the notice to appear to be registered with the court. So don't panic if you don't have a date yet. They may not set it yet. And for those of you who are detained or your family members are detained, it usually takes about 2 or 3 days to get your person registered in the system. So if you can't find them, don't panic. I mean, it won't be the day that they're picked up. It'll be 2 or 3 days after. And you can find them where they are physically located using the ICE locator. If you just look at ICE locator on the internet, they'll take you to where you can find your relative, your loved one. And what they're doing a lot right now is transferring people from one place to another and trying to beat us to the punch in terms of our filings. Because if you're in California and then they move you to Texas and we don't file something in California, by the time you're in Texas, they'll say they don't have any jurisdiction, that they have no authority to rule on your case. And sometimes we have to beat them to the gun and do strategic technical things to make sure it's maybe in a more sympathetic venue, a more sympathetic judge, a more sympathetic state, a more sympathetic court. And by the way, there's been a lot of firings of immigration judges recently because they're not immigrant simpatico, okay, because they are. And so they bring in people who are not very pro-immigrant to be making more of the decisions. And it's very, very concerning, because I appear before the San Francisco court a lot, and we've gotten some very good results. And that may change based on the composition of the judges that they choose to replace with the ones who have left, who have been fired. And we've been seeing people, I mean, I appeared before one judge who later was doing an asylum hearing. And right during the hearing, she got an email. She started crying. She was fired, like on the spot. And so there's a lot of cruelty at different levels happening. I think this is many acts of cruelty. They've turned cruelty into a sport. People think it's entertaining when people are hauled away with people with masks on. And it's a very terrifying and humiliating experience. I say people are not that scared about having to go through a process. It's the way that the implementation of the removal is taking place. There are different ways to remove people. I mean, a person who's been accused of killing 3 people would not be hauled off the way immigrants are being hauled off. And basically, it's an international trespass. You're not supposed to be here, according to the government. And as I say, you have criminal defendants who have very, very serious accusations, and they get better treatment, because the Constitution says you can't mistreat them. And so this is really, really out of line. And by the time the law catches up with them and what they're doing, they've already caused the damage. And that's what's really, really sad. Please.
Yeah. Now, many people assume that once deportation proceedings begin, there are no options left. From your experience, what are the most overlooked forms of relief that could still allow someone to remain in the United States?
At least with the community that I work with, the most overlooked step that they don't take is to get representation. I mean, I interviewed a young lady whose father was detained. Her little sister was traumatized. I asked her 4 or 5 basic questions because her father had been detained. And I was ready to go. He had a case. I don't know how strong. I'd have to research all of the facts, but he had a good case. He had met all the elements based on what she told me. But mom didn't want to go forward. And so it's tragic that people are listening to TikTok and other unreliable sources and just being so terrified that they don't even research. They don't even bother to ask, is there a chance? And so another anecdote is that about 2 months ago, we had a fellow who was detained here in California at the airport coming back from Mexico. And He was detained for 6 months, but we were able to vacate, not expunge, vacate his criminal record. And then I went back into immigration court, and the judge had no basis to keep detaining him. And he was free with his family. He's been free with his family since late August. And so there are victories, there are ways. And if I do an interview with you and I see no path, or there's some things that are just not, that make it impossible for you to get relief, I will not take your money. I will not propose a fee agreement because I already know that you will not qualify. So I don't want to mislead you. I would rather just tell you, I'm sorry, you don't have this person in your family circle, and we need it for you to qualify for a certain type of relief. And so I will just tell you right now. And then they'll go to somebody else and expect a different response, which is fine. They can try to find somebody who gives them a different answer, but it might be a shyster who's just trying to take your money, because the rules are the rules. And if you don't meet the requirements, and you can't because you've come in and out too many times, or you don't have a qualifying relative, a certain type of relative, and you're not going to qualify for a certain type of relief, there's nothing I can do for you. So that's what I do. I say, look, if I see a path, there's no guarantee ever, but if there's a path, I will fight. I will fight for you, and we will do the best we can to try to get you out of detention and get you what you need to be with your family and to defend yourself. And I think people overlook things because they're just ill-accustomed at fighting. And I tell them, look, you're not fighting, I am. You're just defending yourself. And you have a right to defend yourself under the Constitution. And it doesn't matter that you have no documented status. It doesn't, under the law. Despite what other people say or the propaganda, please at least do some initial research and see if there are some possibilities. And I'm very, very aggressive. If I find something that I think could work, I just tell the client what the risks are and where we have some problem areas. And it's up to the client whether they want to go forward or not based on the risk assessment that I've provided.
All right. Now, eligibility for cancellation of removal can be difficult to understand. What factors do immigration judges evaluate most closely when considering hardship, good moral character, and continuous presence?
Well, we have to back up and see what kind of cancellation or removal we're doing. There's 42A and there's 42B. 42B is more common. That is a process undertaken by folks who have no legal status. They don't have legal permanent residency. 42A is for people just like this fellow I described, who arrived at the airport with his green card. They take the green card and you go into 42A proceedings. And so the requirements for each process is different. So when you ask me what do they look at, I can go through it, but it's different for each process, depending on whether you're a legal resident or not, and you're seeking cancellation of removal. Now, physical presence can be interrupted. They say continuous, and there are technical terms in terms of if you commit a certain type of crime, your continuity is broken up. There's a break in there, and it could prevent you from qualifying for the relief that you're seeking because of the criminal record. Good moral character, just generally, there's some crimes that will prevent you from having good moral character. Again, it's just another way of disqualifying you. And it depends on the crime. It depends on the process that we're following. And it's great that you can provide support letters and everything from family, community, etc. But that's not going to make it or break it. What's going to make it or break it is, do you comply with all of the elements? Because that will be my job, we have the burden of proof. We have to show that we've complied with the elements of 42A or 42B for cancellation. And if we don't, then the government will be hopping up and down saying, you haven't complied, you need to be deported. So those are the challenges. For hardship, I just talked to a client yesterday. I won hardship cancellation removal cases, but the best way to win it and the best assurance that you might win it is if you have a child with special needs. So I had a lady, a woman, she came in too yesterday, who has a boy with Down syndrome. And that's a very severe, burdensome disease that if mom is gone, that U.S. citizen child is going to suffer tremendously. I have the fellow who came in yesterday, another client, I said, our challenge is going to be that your kids are okay. Your kids are okay, and that's not good from a legal perspective. I mean, I'm glad they're fine, but it's going to be a challenge to get approved. And so we do what we can. They need to look at the totality of the circumstances, the judge does. And we have psychological reports. I have the psychologist on standby to give testimony. And you first have to have certain relatives whose hardship we can show and who are U.S. citizens. They don't care about the immigrant. They care about how the rest of the family that has legal documentation will suffer if Maria, whomever, is deported. So we have to sort of think hypothetically about what would be the hardship if you're deported? Who's going to suffer? And we have to set that up for the government. And the two scenarios we have to present and persuade the judge about are, what if, let's say mom is the undocumented person, if she leaves, has to leave because she's deported, what hardship will the family back in the U.S. suffer? Scenario number two is she gets deported and the family follows the immigrant back to their home country. And what kind of hardship will that represent? Because maybe the kids are already adapted to the school system here. Dad won't be able to find a good job, medical care, blah, blah, blah. So you have to meet those thresholds in order to convince the judge that it would be an extreme and unusual hardship for the family and other people if you are deported. And so really you have to first assess, do you have a green card or not? Or have you had a green card and they just physically took it away from you? They don't take your status because only a judge usually can take your status away. But that's what we'll fight for because you have a green card. So that's 42A. And if you don't, it's 42B because we have different requirements. For example, if you're undocumented, you need to show 10 years of physical presence. And if you are documented, it's 7 years. So it's a lower amount, but it continues through the time that there's an adjudication. And so sometimes we're just buying time so we can make the 7-year minimum period, So we maybe if we can try to string it out. So we still qualify on that. So you have to make sure that you comply with all the different elements in order to receive cancellation and removal. And going back to options, I always tell everybody, look, worst case scenario, we can appeal. You have 30 days after the judge renders a decision to appeal. And then you get another shot. And then maybe the administration changes and we have a different political climate within DHS, the attorneys on the other side. And I think that we all need to be very, very informed. I'm surprised I'm not blind yet because I'm reading every day changes. And so it's really a challenge to keep up with everything. And I would hope that you would want to fight using me and defend your rights because it's important that you try to remain in the country. For criminal convictions, I actually have partnered with a group in San Francisco that's very reputable. And we have a questionnaire. And if you have a criminal background, you fill out a questionnaire, we send it to them, and they will research and see if they can get rid of those crimes at no charge to you as a client. Because usually we have to retain another attorney to do that. But now we have this wonderful opportunity where they handle that piece and then I'm back in immigration court presenting all of this. So it's a great opportunity to help a lot of people.
Thank you. To everyone tuning in, thank you for being part of this critical discussion. Deportation proceedings can move quickly, and being informed can make a meaningful difference in how individuals and families respond, prepare, and protect their rights. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where immigrants and families can ask immigration related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We are also proud to note that immigrationquestion.com is triple B accredited, reflecting our commitment to transparency, accountability, and community education. Now, Attorney Zarazua, with your years of experience in removal defense, what would you say about a platform like immigrationquestion.com that is helping immigrants understand their options and navigate deportation proceedings more confidently?
Well, you need someone reputable to represent you and look at options. I mean, I just spoke with someone who is from California, and somehow the family retained, an attorney.
I think you're mute there, Attorney.
You want somebody who hopefully is in close proximity. It's just, for me, it's personal meetings sometimes, but I know Zoom is great, and I can practice in any state, in any state in the country. So it's not really an impediment. But I think if you are in California and you want to retain me, I think it's better than going with someone in Louisiana, for example, for so many reasons. Louisiana has very strict laws. They're very antiquated. When we went to law school, I went, over 50 years ago, they'd say, okay, this rule applies in every state except Louisiana, because they've just been kind of historically kind of strange. So in that, examining your options is first, make the commitment, and don't take months thinking about this. Make the commitment to get professional help. That's the first step. And avoid notarios at all costs. They're not allowed to appear before immigration court, federal court. Now, the option that's helping people who are detained, because bonds are very difficult to obtain. I mean, a bond hearing, they've narrowed the people who qualify for a bond hearing, which is just horrific, is a habeas petition. A habeas petition is where you go to federal court and say, they've had my guy locked up way too long. We need to get him out. And so there are many technical options out there. You just need to get the right advice.
All right. Thank you so much for that perspective. We're thrilled to know that. Now, before we move into our live Q&A, one final question. For individuals currently facing deportation or supporting a detained family member, what immediate steps should they take right now to strengthen their case and avoid mistakes that could harm their chances of staying in the U.S.?
In Spanish, I've done about 16 presentations in Spanish. I say, turn your fear into concern and your concern into a strategy. You need to have a game plan. This is an earthquake that may or may not happen, and it's better to be prepared. So what you do is you gather, organize all your important official documents, birth certificates, tax returns, everything that you might need for your defense in one place. Do it on the weekend. Make it a family project, a new tradition that you're going to get organized about your family documentation. And if you have small children, there are attorneys who will do different levels of transferring authority over your children to other people. And you won't lose your rights as a parent. But you want to be able to have someone in charge of making medical decisions at school, and having authority over the children without losing your parental rights. If you have a small business, who's going to keep paying the rent? You have a mortgage, who's going to keep paying the mortgage? You can assign people, do a power of attorney, and have people assigned, and you could have the language in the document saying it only goes into effect if I'm detained. And so if you're not detained, it'll have no effect. You continue doing everything as usual.
All right. If you've just joined us, we've been in an insightful discussion with attorney Blanca Zarazua. on facing deportation, legal remedies that can help you stay in the US. We're now moving into our live Q&A session. This is your opportunity to ask your questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483 and we'll take as many as possible during this session. If they send me a notice to appear, what is the first thing I must do? Leave the US or get a lawyer?
I would get a lawyer unless you're anxious to leave the US. The notice to appear is just the beginning of a process. It should tell you when and where you need to report to. And it's just the first step. And so what you don't want to do is panic. You want to think through what I've just said, which is to calm down and decide who will represent you. You do not need to leave the US. And by the way, self-deportation is a misnomer. There's no such thing as self-deportation. There's voluntary departure. You can leave on your own, but a deportation is because an official or a judge says you need to leave. And just technically, it's the wrong terminology they're using. And they're trying to seduce you with $1,000 and a plane ticket. Really, is your freedom and being with your family that cheap? I would say, I don't think that's enough for me to leave the country. And so it's a big propaganda campaign. I would be very hesitant to just leave. It's not saying that you need to leave. It's saying you need to show up to start your process. And so there's no reason to leave unless you're so terrified that you want to leave. That's up to you, and I can't do anything about it. But if you want to engage in the process and say, I'm going to defend myself, then you find a lawyer and an immigration lawyer, because other people are jumping on the bandwagon, other lawyers who have no experience in immigration.
All right. My TPS has ended. Will my EAD stop? And will ICE try to deport me right away?
The TPS programs from different countries vary. And so I don't memorize all of that stuff. So it just depends on which country you're from. And your EAD could stop very quickly, automatically. And will ICE try to deport me? They don't have the resources. I mean, you're vulnerable if they're in town. They're vulnerable if they're getting somebody else and you have to be there. You happen to be there, they might take you. And there's nobody who can guarantee you won't be detained. It's not about deportation. Deportation rarely is right away. Detention might be right away, but not deportation. And so detention suggests that there's a process that you can follow. Deportation is they haul you away. It's usually for people who already have an existing removal order, and it just resurfaces, and they don't have to give you any process or any opportunity to address a judge. So I do not think that they'll try to deport you right away unless, well, first they have to find you. And then unless you have a previous deportation order and you just didn't leave, removal order, and you chose to stick around, then they might deport you expeditiously.
All right. Will USCIS still issue me an NTA even after my family visa petition?
You know, they're doing so many strange things that nobody can say, don't worry. They might. I mean, people are getting NTAs for so many reasons. And if you've only filed the petition and it hasn't been approved, I mean, technically you have no status. If that's all you have, is that the petition is pending. And, you know, they give you these notices when you send your petition and you get a receipt, and then they put this does not offer any immigration benefit to you. They're just saying, okay, we've got your petition, we're going to process it, and that's it. So technically you're exposed. And they may issue you an NTA. it's more likely they would issue an NTA if your petition is rejected. I mean, people go to notarios, they do a terrible job. There's some defects in the application, even though the person qualifies. And then they get an NTA. I mean, before you'd just be rejected and that would be the end of it. But now if they reject you, you could be receiving an NTA.
All right. All right. Before we wrap up this session, I have one last question. When someone receives a notice to appear, what immediate legal steps should they take to protect their rights and ensure they do not miss any critical deadlines in immigration court?
Well, as I said, there may be a delay between receiving the NTA and filing the NTA. And so you may not have a court date yet. And so you want to look at the automated case information system. And anybody can go on the internet and then just put in their A number or their name. You try to go through there and see if they have assigned you a court date. They may not have. And it won't be tomorrow. I mean, you'll have time to attend. What you don't want to do is not attend. I don't care what's going on. You need to attend. Or, I mean, there's really no excuse for not attending. And technically, they could issue a removal order just for the failure to appear. And so that's how you can really jeopardize your case. After that, if you have a representative, I mean, I am always notifying people you have a date in March of 2026, and then we remind them and blah, blah, blah. So there should be no reason for you to miss your court date. It's on the internet. You should be retaining someone to represent you who should keep on top of it. And just to let you know, the first court appearance is usually called a master hearing, and it's more administrative. It's about calendaring and who's your lawyer and when do you think you might be ready to go to trial and what legal theories are you going to use. I mean, the judge wants to know what your game plan is. So it's not like you have to take any documentation to that first hearing. Nobody's going to be presenting evidence or any of that. Unless the lawyer for some reason says, I want to get out of here quickly. Here's an approved I-130, an initial family petition. And let's move this along quickly because this person's going to adjust and be a resident very soon. So why are we here? So the lawyer may have reasons for submitting evidence, but I wouldn't worry a whole lot about that.
All right. Thank you so much, Attorney Blanca Zarazua, for sharing your expertise and guidance today. Your insights provide clarity and direction for individuals and families navigating the stress and complexity of deportation proceedings. And thank you to everyone watching for joining us today. We hope this webinar helps you stay informed, prepared, and confident as you navigate your immigration journey. Remember, you can always visit immigrationquestion.com to ask immigration questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's discussion or share it with others, the full replay will be available on Spotify soon. Just search for Borderless Talk by immigrationquestion.com. Join us again next week for another live session covering family immigration, asylum updates, green card processes, and compliance developments. Thank you again, Attorney Blanca Zarazua. And thank you to everyone watching. Until next time, stay informed, stay prepared.
Don't underestimate your value in this country. Do not underestimate your value and contributions to this country. Forget the rhetoric. You're valuable, you're essential, you're vital to the economy and the healthiness of this country. So please don't feel terrible about your status. That doesn't define who you are as a person. You're a valuable person, irrespective of your status. Thank you.
Thank you, Attorney.
Thank you.